Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the story of a Manitoba medical student who was expelled from his school after failing to satisfactorily apologize for his views on guns and abortion, or to change his conscientious beliefs. The expulsion went all the way to the Manitoba Court of Queen's Bench, where the court has now found bias in the school's decision-making process and ruled that the student does have a charter-protected right to freedom of expression that must be respected by the school's disciplinary process. This is a victory for freedom of expression and freedom of religion. And here today to talk about what happened is the student's lawyer, Crosson. Carol, thank you so much for joining me today. I've been following the case, and I want to congratulate you on your success. Now, let's start from the beginning for our viewers who may not be familiar with what happened. Can you tell me about your client, Mr. Zaki, who he is, what's his background, and then about the program he was in Manitoba?
Certainly. Nice to be with you today, Christine. Raphael Zaki was in his first year of studies at the Max Rader College of Medicine at the University of Manitoba when he posted on the right to bear arms, some links to videos in the States on the right to bear arms. And he also published a pro-life post on his social media. Raphael is a Coptic Christian. His parents immigrated from Egypt with the purpose of finding freedom in Canada. They had some concerns about freedom of religion, where they came from. And during that first year, there were some complaints that were made about Raphael's social media posts. And they were made by 18 complainants, anonymous complainants, through a process which allows that at the university.
So let's talk about those posts. What can you tell me about the posts that triggered these complaints and the disciplinary proceeding?
Well, the posts were two of them, as I say, to pro-arms videos. And then the third was a pro-life paper, a very lengthy pro-life paper that Raphael had written for his Sunday school. He hadn't really intended it to be anything other than that he has shared. And I think it was that post that also really offended some of the students, if you want to say that. It was somewhat hyperbolic in nature. We have admitted that before the court. And that is why, of course, Mr. Zaki apologized many times for how he shared his message in that post.
Yeah, I think he was asked to apologize for the tone of the language that he used, which I think you've conceded was a little hyperbolic. Now, let's talk about the complaints. These complaints were made through a system that the school had created under the Prevention of Learner Mistreatment policy. What can you tell me about the nature of the complaints? What specific rules had he violated or alleged to have violated?
Well, there's only so much I can tell you about the complaints because amazingly, Christine, we've never received the full complaints. Mr. Zaki never did. We went through how many hearings and we've never seen the full complaints. It was really only after he was expelled that he saw partial comments from the complaints. And so those partial comments reflected that he was accused of being, for example, transphobic, racist, and homophobic, which he categorically denied. But it's pretty difficult to deal with complaints that you have not seen the full complaints.
Oh, I can imagine. How do you apologize when you don't know what's been done, what you've done wrong to upset these people? But I think the nature of the complaints was that he had violated a professionalism requirement. That was what the school was saying. Is that correct?
Eventually, that is what the school said. Initially, he was asked to attend, I think there were 7 in nature, meetings with the assistant dean, primarily Dr. Ripstein. Some of the meetings had other participants, but it was primarily Dr. Ripstein he met with. And that was part of the investigation, and Dr. Ripstein headed that investigation.
And the investigation and ultimately disciplinary process led to Mr. Zaki writing a number of different apologies. which the schools wouldn't accept. Continue to write multiple drafts of these apologies. When we come back from these commercial messages, I want to talk about why you think, or why Mr. Zaki thinks the school wouldn't accept the apology and what exactly they were looking for. We will be right back from this break. Welcome back to Canadian Justice. We're talking about a case involving a student who was expelled from the University of Manitoba Medical School for his views, religious views about abortion. And I'm speaking now with his lawyer, Carol Crosson. Now, Ms. Crosson, Mr. Zaki had agreed to write an apology for his posts, but the college would not accept his written apology. What can you tell me about why they wouldn't accept the apology?
Well, as I share with you today, Christine, really all I have is the record that was before the court. And so in the record, the fifth apology was the one that led to his initial expulsion in August 2019. And in the letter, which expelled him, the deans said his apologies were, quote, insufficient due to a lack of insight into the professional obligations of a medical student. And his apology, his last one, lacked sincerity, because there was no evidence of personal exploration or self-examination of his attitudes. And so that was the explanation. Of course, Mr. Zaki, it wasn't just 5 apologies that he provided. Those were the apologies that he provided for the college. He also wrote letters of apology to the other classmates. And his fifth apology, I actually read it at the hearing. It's 5 or 7 pages long. It was a very, very lengthy apology, basically apologizing for how he could have said things different, how he would understand if people were offended by his post, that he wished he wouldn't have brought up this and that. There was one thing, though, Christine, that he would not apologize for, and the judge said it in his reasons. He would not change his beliefs. And in the submissions of the college, all the way through, Dr. Ripstein maintained the position that Mr. Zaki would not change his beliefs. And that was the thing that Raphael could not do.
Yeah, and that was actually in the decision, which I read. The court included in the decision a letter from one of the people involved in the disciplinary process who said that the apology lacked sincerity because he hadn't changed his views. Do you think that what the school wanted was for him to change his religious convictions as it pertained to his pro-life beliefs?
All I have is the record, and in the record repeatedly, submissions were he would not change his beliefs. Yes.
So one of the things that you challenged in the decision to expel him, because it ended up going to court, was that there were three things that made the decision unreasonable. First, that it lacked procedural fairness. Second, that there was a breach of his charter rights. And third, that the court lacked jurisdiction to even hear this case because this was posted on his personal Facebook. What can you tell me about the first argument, that there was no procedural fairness in this case? What do you mean by that?
Well, we had a number of reasons for making that argument, but probably the barest reason was that, or the most clear reason was that he never did see the case he had to meet. Before he was expelled, he never even saw partial complaints. So it was very difficult for him to know, what am I apologizing for? What have I done? How have I offended them? Because he couldn't read the complaints. And we maintained on the law that a student on threat of expulsion should see the full evidence against them.
One of the other things you argued was that the decision maker who expelled Mr. Zaki had a reasonable apprehension of bias. And the court actually made a finding on that. What did the court hold on bias, and what example can you give me of the bias that the decision maker had?
Yes, that's a very interesting holding that the court put forward, and we're very happy to see that, because all along it was like the matter was predetermined, and Dr. Ripstein, who held a very important role in this, actually fulfilled duplicative roles. The court accepted that he was both the investigator and the prosecutor in the matter. He initially held the investigation 7 meetings with Mr. Zaki. And then he went to a committee called the Progress Committee, worked with that committee to take the findings of the investigation.
What a name, too, the Progress Committee.
Yes. And then the Progress Committee made a recommendation back to Dr. Ripstein after he had gone to them with his view. And then Dr. Ripstein was one of 2 individuals that expelled Mr. Zaki, but it didn't stop there. Then it went to another committee in which Dr. Ripstein presented submissions. And then at the upper level appeal, Dr. Ripstein was the main witness. So he was involved all along. And the concern from the court was that the upper level committee didn't ever really examine, at least in their communicating of their decision, the role that he had fulfilled. They had simply adopted his bias.
We will be right back after this commercial break. Welcome back to Canadian Justice, where we're talking about a case involving a student who was expelled from the University of Manitoba Medical School for his religious views about abortion. And I'm speaking now with his lawyer, Carol Crosson. Now, Carol, in the last segment, we were talking about what the court found that the disciplinary procedure that had expelled Mr. Zaki lacked procedural fairness, in part because of a reasonable apprehension of bias by one of the decision makers. But another thing you argued was related to the question of whether the school actually even had jurisdiction to punish this student for personal Facebook posts. What did the court decide on that issue?
The court did not side with us on that issue. There's a procedure under which Mr. Zaki was disciplined. And under that procedure, it says that the university has the right to regulate social media if the social media is regarding the university or its members. Our argument was Mr. Zaki's post was not about the university or its members. It was about a Sunday school post that he had for his church. And so, but the court differed with us on that because the court found there was enough evidence that the social media was directed to individuals at the university.
I mean, it seems like a pretty broad interpretation to me. Can you, Carol, imagine a scenario where social media posts may not fall under the jurisdiction of the school? I mean, he has friends from the school on his Facebook. But for example, if instead he had titled it, here is a lecture I prepared for my Sunday school, do you think maybe the decision would have been different? Because I'm not convinced his classmates wouldn't have complained about that too, even if it's clearly not directed at them.
We argued that, Christine. We find it difficult to think of a situation where a student wouldn't intend their social media to also go to their classmates. Yes, and that was our problem with jurisdiction.
Yeah, interesting holding there. But for me, what the most interesting part of this case is the charter argument. Because it really is unsettled law about whether the charter applies or doesn't apply to a university disciplinary decision. And there's been conflicting case law from across Canada on this issue. So what did the court find in your case?
Well, I'm happy to report that the court, from this moment forward, the court's decision means that the charter applies to student discipline on the campuses, post-secondary campuses in Manitoba. And of course, that's landmark. You're right. There's conflicting jurisdiction across Canada. And as a constitutional lawyer, that's a matter of concern for me. And so we're very happy to see that. The court found that under an Administrative Education Act that's over the university in Manitoba. So we're thrilled to see that this point forward, students like Mr. Zaki, if they share something that bothers someone, the charter will protect them and the university will have to consider the charter. The university did not do that here.
Yeah, and of course, for our viewers, the charter is what guarantees your right to freedom of expression, freedom of religion. And so this is a really big decision. Will be interesting to see how it is applied in future scenarios. Carol, what do you think it will mean for non-academic student discipline on campuses in the future?
Oh, Christine, if I could count the times that students have said to me, but I don't have a right to free speech on my campus. People are stunned by that because universities are supposed to be bastions of free speech, but yet there's no protection. It should be the place where speech flourishes. And so this will push that forward for all students, not just for Mr. Zaki. Students, no matter what they believe, will now have that protection on campus.
Yeah, I know, Carol, you've mentioned these other students, and I know you have worked with other students. For example, I'm familiar with one of your cases in Ontario related to a Ryerson student who was let go from his role with the student newspaper for his views on abortion. Do you think that this decision, it's coming out of Manitoba, but do you think it will have bearing on that Ontario case?
I don't think technically it will, Christine, because you're speaking of Jonathan Bradley. He was terminated from the Eye Opener, a student newspaper on the campus at Ryerson, and that is before the Human Rights Tribunal of Ontario right now. Technically, the Eye Opener is a private corporation, and so the charter does not apply in the same way, but the principles do. And I think the principles behind the Zaki case will help Mr. Bradley, because it's a recognition that free speech should be cemented on these campuses. If that's what a university is for, so they can go to school and learn varying perspectives, surely Mr. Bradley, as a journalist, should be able to have his perspectives privately.
Yeah, I mean, isn't it ironic that the places where you're supposed to explore new ideas and in journalism of all places that speech is being restricted? It's certainly really interesting. When we come back from this commercial break, I want to talk about what the future holds for Mr. Zaki. Welcome back to Canadian Justice, where we're talking about a case involving a student who was expelled from the University of Manitoba Medical School for his religious views on abortion. And I'm speaking with his lawyer, Carol Crosson. Now, Ms. Crosson, what's going to happen next for Mr. Zaki after this decision, this important decision? Does he get to go back to school? Can he finish his medical degree? What happens next?
Well, things are very much up in the air, Christine. The court remitted the matter back to the upper level committee. Whether the upper level committee will entertain it and make another decision is yet to be determined. And we're in the process of advocating for Mr. Zaki to immediately be re-enrolled. We hope that's the case. I'm thrilled about this, though, for even outside the practical purposes, which are, of course, crucial. But Mr. Zaki's family came to seek freedom in Canada. In fact, his mother is a doctor. And I am thrilled to see that after all this, and they have been through a lot, they have finally seen that there can be some fairness in our Canadian system to those that have a religious faith.
So how is Mr. Zaki doing? How is he feeling about the decision and about his future?
Well, it's been a long road for him. It's a long road for any client that I have. In fact, I run a constitutional organization, a charity, which helps individuals like Mr. Zaki. It's called Rights and Freedoms Advocate. And I find that people that go through these things, it's harrowing. They suffer a great deal of injustice because all they want is just to be treated evenly and not persecuted for their opinions and beliefs. So I think it's wonderful that the end of the road for Mr. Zaki. I'm very happy to see this result.
And what do you think the school's going to do next? Do you think that they have the option to appeal this decision? Do you have any insight into whether they may do that?
No, I don't, Christine. That's yet to be determined. They'll have a 30-day period in which to decide that.
Well, it'll be certainly interesting to see what the future holds. I think that this decision is going to have a really big impact on university campuses, especially the aspect where it's holding that the charter applies to the school disciplinary process. I think that's really a really big deal that I want to make sure our viewers understand that. Your charity, the Rights and Freedoms Advocate, how do people learn more about that? How do they get in touch with you if they're faced with a similar situation?
They can just look up freedomsadvocate.ca, and we're there to stand beside anyone whose rights are threatened. We have a variety of cases. Basically, the beneficiaries of the charity are those people that right now have the guts to stand up. They have various beliefs and opinions. That's not what counts. It counts that they have that right to share those beliefs and opinions.
Absolutely. And I think there are a few organizations that do the type of work you do, Carol. I also, as you know, work for a charity, the Canadian Constitution Foundation. We weren't involved in your case, but I certainly found your case fascinating, and I think it's going to have a huge impact. So thank you for all the work that you do advocating for these issues, free expression, freedom of religion. They are really fundamental rights, and I do think that they are under assault on campus, whether culturally or through disciplinary proceedings like this. So, Carol, thank you so much for coming on today to share the story of your client, and I hope he's doing well.
Well, thank you, Christine. I so admire the work you do as well. Thank you for the contribution you make to this Canadian culture.
You too. Thank you, Carol. We've heard today about a case where a student expressed his views on controversial topics and as a result faced life-changing and serious discipline from his university. Now, let's not beat around the bush. The language that Mr. Zaki used was inflammatory and hyperbolic, but he apologized for it. But what he could not apologize for was his core religious view, and he shouldn't have to. There's a term for people who have views that don't conform with accepted or mainstream standards or beliefs. We call these people heterodox thinkers. Mr. Zaki may be of an orthodox faith, but within the university, his pro-life views are decidedly heterodox. He should not be punished for these views, and universities need to accommodate minority views not just as lip service, but in fact. The decision in the Zaki case will have widespread consequences for other heterodox thinkers on campuses across Canada. But what do you think? Will this case have a big impact? Will universities start to accommodate a wider variety of perspectives on campus? Or is the tide of conformity too powerful to push back against? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.